those were the headlines, and let's now take a look at our top story on South Central, and this is related to India's crypto landscape, which might have just crossed a crucial legal threshold. In fact, in a ruling involving S.I.R and in a first, the Madras High Court has ruled that the cryptocurrency qualifies as property under Indian law. The case stemmed from an investor's petition whose XRP tokens, which is again a type of cryptocurrency, were frozen on S.I.R, which is again a cryptocurrency trading platform, and this after a cyber attack. In fact, the court has held that the crypto can be owned, enjoyed, and held in trust like other assets, effectively granting digital investors legal protection and enforceable rights. But how significant is this ruling, and what does it really mean for investors of crypto? Well, let's try and decode some of those points with B. Shravant Shankar. He's an advocate of the Supreme Court of India, and he is joining us live on the show. Thank you very much, Shravant, for taking the time out and speaking to us here on ET Now. Now, of course, we'll come to the implications of this ruling, but let's first address how crucial is this, and what exactly is this ruling all about? What does it really change as far as the crypto landscape in the country is concerned?
Thank you so much for having me on your show, Sumita. This ruling is very significant, keeping in mind two important aspects. First of all, we're going to the background. There is no global treaty or convention with respect to crypto till date. And India has incorporated some of the Financial Action Task Force, FATF, the recommendations. However, only in 2022, we have included crypto as an taxable income, and 30% of flat tax has been applied on it with 1% TDS. And like you know, the cryptocurrency and regulation of official digital currency bill, which is also called the coins bill, which is still pending in the parliament. Now, coming to this judgment, it's very important because the High Court of Madras has recognized cryptocurrency to be an asset while giving security to the petitioner to have protected their assets which were frozen by the platform.
Right. But Shravan, what are the implications of this ruling, especially if we talk about, the investor community or, of course, the crypto sector as a whole, which has been highly and heavily regulated?
Yes, then I can suggest 5 of them. One being the fiduciary duty of the host crypto exchange platform is heightened, and the users are secured as legal owners of their proprietary rights. Second, investors who are merely users of platform are now legal owners with proprietary rights which can be contested in a court of law, including injunctions, trust claims, restitution, insolvency protection, civil suits, and criminal proceedings. 3. Judicial recognition has now outpaced legislative framework. Therefore, there is an urgency for comprehensive regulation. 4. Further, the customer protection framework may also need to be looked up to. And lastly, the property status which has been legitimized, the existing tax regime of 30% tax and 1% TDS. Therefore, this judgment strengthens the government's position to enforce mandatory disclosure.
Right, so you're essentially speaking about mandatory disclosure, and of course, while crypto is, the Madras High Court did rule that crypto can be recognized as a property, but Shravant, you do have to understand that crypto is still not legal tender in India, so how does that ruling fit into this reality that the country faces?
So although crypto is not legal tender in India, in fact, I can think of only one country, El Salvador, where it is legal tender. Even if you go to Dubai, there is Virtual Assets Regulatory Authority, which regulates use of crypto in Dubai. So crypto is not a reality of tomorrow, which is a reality of today. So when having government been very well aware that crypto has been traded and tax implication has been brought in, and in fact, government is proposing to create its own official cryptocurrency to be issued by the RBI through the coins bill, which is in the parliament. So it has although it is not a legal tender, government has acknowledged that this has been traded upon, because like you know, Sumita, crypto can be itself traded like silver and gold. So therefore, government very well knows that people are earning profits. Of course, there are a lot of hesitations or risk involved with respect to money laundering, terror financing, illegal trade, etc. But government knows that it is the reality of today with respect to taxation and with respect to protection of rights of the consumers who have purchased the cryptocurrency, especially the fiduciary responsibility of the host crypto exchange platforms has been brought up. So that is the significance of it, as I understand.
Right, but what are the additional regulatory risks that remain?
Regulatory risks that remain, first being when crypto is mined, the biggest regulatory risk right now today is that crypto can be purchased anonymously. You did not have to disclose your official documents or personal data, and all of this has been regulated through the blockchain, which is the digital ledger, which actually tells you the provenance of the cryptocurrency. So therefore, the risk of double spending or counterfeiting is zero. So when the entire regulator is with the host platform, for the government to be able to enforce guidelines which are equivalent to what you put for a legal tender is something the government is should be looking into. And also, of course, the consumer specific guidelines, because people who purchase crypto after having it mined and trading it, they have several risks. Say, for example, in this case, WazirX platform had two kind of cryptocurrencies, XRP crypto and ERC20 crypto. And there has been a cyber attack due to which this petitioner's cryptocurrency was frozen. Then this petitioner goes under Section 9 of Arbitration Act to Chennai High Court, the Madras High Court, and seeks protection of her cryptocurrency so that the host platform does not socialize the losses, in the sense that they don't take the losses and give away to other people who have actually suffered a loss, while this petitioner did not suffer a loss. And what is very interesting here in this case is they have referred to two judgments of the Supreme Court of 1969 and 1995, interestingly saying that everything that has exchangeable value or which goes to make up wealth or estate or status constitutes asset. And further, using another judgment, reading into Article 300A of the Constitution to define property. So, going into the definition of property, say your immovable properties are regulated by A, taxation, two, registration,
Right.
three, with respect to other GST implications. So, with respect to bringing in uh, direct tax has been done. Indirect tax could be something they may explore.
Okay. Right. Okay, okay, and we'll have to see, what else does the Indian government explore. But specifically coming back to this particular ruling, Shravant, what are the implications for crypto holdings on foreign exchanges or wallets when held by an Indian resident outside of India?
So this particular judgment only deals with cryptocurrency which has been purchased within India, does not go into the international ambit. Although what may interest you, if I may read three sentences from the judgment which are very relevant for our understanding. The court finally summarizes the entire ambit of this question while granting relief to the petitioner. I must tell you that the court says, I quote, there can be no doubt that cryptocurrency is a property. It is not a tangible property, nor is it a currency. However, it is a property which is capable of being enjoyed and possessed in beneficial form. It is capable of being held in trust. So, going into this definition, they have put themselves into the confines of the Indian jurisprudence only, while dealing with an arbitration which is actually seated in Singapore. So, whoever purchases cryptocurrency on WazirX platform, they are bound by an arbitration contract where the seat of arbitration will be Singapore. Although the value of the cryptocurrency was about 9.5 lakh Indian rupees only, the Madras High Court has gone in to say that yes, of course, there is clear jurisprudence, even if the seat is outside for interim relief because cause of action has arisen in India, you can go to an Indian court to secure your property. But the court has, while having dealing with arbitration law on the international front, has confined itself to the domestic laws only. Although I must tell you, Sumita, there is one UK judgment of the House of Lords where four
Right,
qualifications of an asset have been dealt with, but it
right,
does not really help us on the international front
right,
of regulation.
right. Right, Shravant, let me also ask you, since crypto is legally now, according to what the judgment essentially says, that it is property, does that mean that a holder has stronger recourse in cases of loss, theft, or freezing of assets?
Absolutely. Here, what you see, Sumita, Interestingly, arbitration allows you to take what you call a 39(1) and 2 interim relief in a civil suit after filing the suit. In arbitration, you can do the reverse. You can actually protect your property and then go to claim it, claim your full rights on it. So here, what the court has actually acknowledged the right because it's a taxable asset. Once you transact, the profits are taxable by 30%, has given them relief. So coming there, you have now right to move courts for injunctions, trust claims, restitution, insolvency protection, civil suits, and maybe criminal proceedings. Like say cyber attacks, you can lose your cryptocurrency like in this platform. So probably investigating agencies can also take over from here, considering this to be uh, a valuable asset. So will it be coming into forging valuable security or not is up to the courts to decide next. But that is something what will be very interesting to look at.
Absolutely. And that is something that we'll also keep a close watch on. But Shravant, how might this ruling influence upcoming regulation of virtual digital assets or VDAs by the government or regulatory bodies, for instance, the Reserve Bank of India or the Securities and Exchange Board of India?
I firmly believe it will have a very positive impact on it. It only strengthens the direction in which all the regulatory bodies and the government is going into. Because once you protect a citizen of their rights on a particular asset which they have used a valid legal tender to purchase it. So to mine a crypto, uh, you don't need to put valid legal tender, but to purchase a cryptocurrency even in a form of an NFT, you need to put valid legal tender. So when I'm putting currency to buy a crypto, then I have as much right on the crypto, so much as I would have on, say, a gold or a silver, or say any stock market equity which I would purchase. So it will have a similar impact on it.
Right, but Shravant, one final question before we essentially let you go, because experts have suggested that implications are not absolute and it could face an appeal. So, on what grounds will an appeal be sought?
So probably, see, I completely agree because Section 9 order is an appealable order and it can be taken all the way to the Supreme Court. And this is the first time this particular issue of law has been answered. So to going to defining and giving a legal sanctity to cryptocurrency in a court of law, this has been the first time. Till now, the question has been what we say in legal words, res integra. So going forward, for someone to challenge this in the sense that this being an asset would be limited to the tangibility and non-tangibility of it, and also how much mobility this particular asset has. Say, for example, if you want to buy a car or a property in India, you can't use cryptocurrency to purchase anything. It is an asset, it is non tangible, but again, it is not transactionable. So, in the sense, going into the actual definition to give it the same status as you would have for a car or a property or even say currency, it may not fit into the definition completely. So on these grounds, probably there is a possibility for a court to interfere. Although I have my certain reservations in fact that with highly unregulated the market being, the entire exchange of crypto market, and several from Bitcoin starting to WazirX, there are several platforms dealing with it. It may require a completely different regulatory framework, like how SEBI is a completely different framework for it to be regulated, because how technically intense the entire what is a gamut of cryptocurrencies. Like you really need supercomputers and you have to solve complex mathematical problems to actually mine cryptocurrency, which is limited. Means once a cryptocurrency is limited to say 10,000 cryptocurrencies, it can never be increased thereafter. Keeping that in mind, it is a completely different kind of what do you say valuable which can be exchanged. So probably the courts may interfere to the how highly technical this particular
Right, sir.
currency is. That's all.
Right. Right, and definitely, Shravant, India's crypto landscape seems to have crossed a legal crucial threshold. We'll have to see how this space really develops further. And of course, this is an observation that's been made by the Madras High Court. But does it have an impact on how India sort of deals with regulation of cryptocurrency? And of course, as far as a law on cryptocurrency, as far as that is concerned, we'll have to wait and see. But for the moment, thank you very much for taking the time out and speaking to us here on ET Now.
Thank you so much, Sumita. Have a good day. My pleasure.
All right, ladies and gentlemen, time now for us to look at some other stories that are making news in the southern part of the country, because ED has said that its November 7 searches against board members and directors of NIMOM Cooperative Bank in Thiruvananthapu, associated with some CPM netas, have revealed misappropriation of funds to the tune of over 50 crores. And that with then office bearers who were found involved in forging documents, sanctioning loans beyond permissible limits, also diverting funds, and overall financial mismanagement that led to the failure of the bank to honor deposit liability. So ED has uncovered a scam, and those are some of the points that are related to that scam being uncovered at NIMOM Cooperative Bank in the southern part of the country. And that particular bank, ladies and gentlemen, is currently under the ED lens. But a major food adulteration scam has surfaced, and that involves Andhra Pradesh's Tirumala Tirupati Devasthanam's TTD, one of the country's most revered temple trusts. Reportedly, an Uttarakhand-based dairy has allegedly supplied 68 lakh kgs of ghee worth 250 crores to TTD between 2014 and 2019 without procuring any milk or butter during that period. Now, a CBI probe has revealed that the ghee was used to prepare the temple's iconic Laddu Prasadam, and that was adulterated. The Special Investigations Team, or SIT, uncovered the details following the arrest of Ajay Kumar Sugandh, who allegedly supplied chemicals such as monodiglycerides and acetic acid to Bole Baba Organic Dairy. Now, that's a supplier that was contracted by TTD for ghee used in laddu preparation. Although the dairy, which adulterated the offerings, was blacklisted in 2022, it allegedly continued supplying adulterated ghee to TTD by routing contracts through other dairies, including Tirupati-based Vaishnavi Dairy, UP-based Malganga, and Tamil Nadu-based AR Dairy Foods. So that's an update that's coming in from TTD, Tirupati Tirumala Devasthanam, and this is related to Tirupati Laddus coming under lens once again. But news now also coming in from Tamil Nadu, wherein the state's ruling DMK-led Secular Progressive Alliance today staged protests across the state, urging the Election Commission to halt the S.I.R. and Chief Minister M.K. Stalin said preventing the exercise from getting implemented was a huge responsibility. Now, Stalin, who is also DMK president, said that on the one hand, one legal battle was against the S.I.R. that took away the basic right to vote, a basic feature of democracy. Also, on the other hand, the party has taken steps to tackle the exercise, which has commenced by setting up war room and helpline to prevent goof-up during its implementation. So that's as far as the S.I.R. controversy that's brewing in Tamil Nadu is concerned. And of course, those are some of the pictures that we have for you in terms of the kind of protests that that took place today at several locations, at least 43 locations, we are told, from our bureau correspondents based in the state. But time now for us to also take a look at this special story that we have lined up for you. Now, what if assistive technology could become the bridge between limitations and limitless possibilities? Well, Samarth by Hyundai, an initiative by Hyundai Motor India Limited, is paving the way towards an inclusive and accessible world for people with disabilities. Through this platform, we're celebrating change makers and innovators who prove that imagination knows no bounds. Meet one such visionary entrepreneur who's making cinema more inclusive and accessible for persons with disabilities through its audio augmentation platform. And let's have a look at this special story to know more.
Cinema connects hearts through stories. But for millions who cannot see or hear, that connection is out of reach. Excel Cinema changes that, turning technology into inclusion and making every seat in the theatre a place of belonging.
The core belief with Excel Cinema's team is inclusion. We don't believe that persons with disabilities need to have a separate solution. Instead, Excel Cinema is universally designed to make theatres accessible to all.
I was always in the pursuit to develop something which is more impactful. And the chance came in my way when I co-founded Excel Cinema with Dipti, which actually empowered, made people with disability more samarth and able to access content.
It's not only one person with disability that impacts when we include them in our entertainment. It is their entire family. It is that entire office. It is that entire circle of friends which get included when they enjoy a movie together.
एक्सेल सिनेमा से ऑडियो डिस्क्रिप्शन से अब मुझे किसी की मदद लेनी नहीं पड़ती है। मैं खुद से सब कुछ समझ के सिनेमा देख लेता हूँ और बहुत मज़ा आता है।
स्टार्टिंग से ही, बचपन से ही मुझे मूवी देखने का बहुत ज़्यादा शौक़ है। तो पहले मैं मूवी देखता था, आंखों से देखता था, लेकिन आज की डेट में मैं मूवी देखता हूँ इंडिपेंडेंटली एक्सेल सिनेमा की हेल्प से।
Indian cinema has over 1 lakh movies available in the public domain, which is inaccessible. Hence, NovaFlix is launched to create accessibility features for these content and provide them to the visually impaired community of India.
पिक्चर सामने चल रही थी होती थी पहले, उसमें डायलॉग मुझे सुनाई नहीं अच्छे से देते थे। आज मुझे डायलॉग सुनने की जरूरत नहीं पड़ी है एक्सेल सिनेमा की वजह से, क्योंकि वो सारी चीजें मुझे साइन लैंग्वेज में बता रहा है।
We are constantly evolving, constantly developing texts which will assist them to become mainstream.
We are running Sugam Cinema Yatra, where we take movies to blind schools, NGOs and hostels, where we create awareness about digital literacy, about accessibility of entertainment content and other platforms that are useful for persons with disabilities.
India, having the highest number of visually impaired and hearing impaired, is not to be seen as liability. So we have to empower today so that they can support us tomorrow.
एक्सेल सिनेमा ने मुझे समर्थ बना दिया। अब मैं कोई भी फिल्म अपने आप से देख सकती हूँ।
In a truly inclusive world, the lights don't dim for anyone. Because when everyone can watch together, that's when the story is complete.
Well, definitely that initiative is paving the way towards an inclusive and accessible world for people with disabilities. Well, on that note, ladies and gentlemen, it's time's up from us on South Central. Thanks for watching.